Imagine you're in a long and nasty family law dispute, and one day you walk into court and the judge suggests there won't be a trial until you sell a home to pay a lawyer you never hired. Find out what the appellate court has to say about this after the jump. Hello again. Before I start, a quick thank you to all my colleagues. I do everything I can to get these commentaries right, and your viewership means a lot. I try to gauge which cases are going to be, I guess, the most helpful, and my best metric, and really my only metric, is either a like or a subscribe. I don't get paid by YouTube. It's just something I look at to see if a particular subject area deserves more or maybe less attention. That said, let's talk about more interesting things such as this gentleman, Michael Polos. He's not only a lawyer, he's also a trumpeter, a conductor. Here he is on the cover of Loyola Law School's magazine. His wife plays soprano because they're both part of the Chicago Bar Association Symphony, oh my goodness, Orchestra. To show you how touch I am, I didn't even know this was even a thing, and it's not a bunch of lawyers playing community music theater here. So Michael represents a third-party defendant on an interim fee challenge. For my non-lawyer audience wondering kind of what I'm talking about here, let's bring in April for a second to kind of get you up to speed.
The purpose of awarding interim attorney fees is to level the playing field by equalising litigation resources where it is shown that one party can pay and the other cannot. Any interim award is made without prejudice to the final allocation of attorney fees, and at the conclusion of litigation, upon proper motion, any portion of any interim award constituting an overpayment will be remitted back to the appropriate party or counsel, as the court determines and directs. Most importantly, because interim fee proceedings are temporary in nature, they cannot be appealed on an interlocutory basis.
Normally, I gloss over the facts. Let's face it, y'all came here for the holding anyways. But the facts play a significant role in this case. Brass tacks is a long, nasty divorce case. It was filed, I think, in 2012. A judgment goes up on appeal, it's reversed, comes back down for a new divorce trial, and for whatever reason, it languishes for 6 years, and I have no idea why. Sometime in 2020, the husband's lawyer seeks interim attorney fees. He gets an award for $100,000 to be paid from the equity of the wife's Florida home. This home also belongs in part to the appellant in this case, who is the third-party defendant. For whatever reason, the wife refuses or whatever fails to sell the house. The judge then orders it be listed and sold so the lawyers could be paid, and the opinion infers very heavily there wasn't going to be a trial until this is done. I don't know if that's the case or not, but in either event, the third-party defendant appeals saying, hey, what about my rights? I'm not part of this divorce, but I'm part owner of this house. Now, first, there's a battle over jurisdiction. As longtime viewers know, it doesn't matter how right you are in your case. If it doesn't fall under the 300 or the 600 series rules, you can't appeal. So the husband files a motion to dismiss for want of jurisdiction, stating that interim fees can't be challenged. Because generally, that's true. The only way you can challenge interim fees outside of a final judgment was to be held in contempt, then appeal the contempt finding. Now, I know this sounds nuts, but just stay with me here for a second. You can only be held in contempt for refusing to comply with lawful orders, or otherwise referred to as valid orders. If the order isn't valid, well, then the contempt can't hold. And a great example of this is this case, which addressed disgorgement of attorney's fees. And historically, efforts to sort of find ways to end around this by attacking the machinations of enforcement have also failed. In this case, the husband tried to challenge a garnishment order that was entered to enforce the interim fee order, not the interim fee order itself, if you can follow me. And I have to admit, it's pretty clever, but it didn't work. However, the court in this case says we have jurisdiction under Rule 307A, which covers injunctions. And this makes sense if you think about it. Once the house is sold, you can't really undo it. You can't be allowed to live in it, and that kind of leaves that third-party defendant, who is part owner, kind of out in the cold. Moving on, the court then reverses the trial court order, and the biggest reasons were the uncertainty over the ownership of the home, the third-party interest, and maybe more importantly, there was nothing in the record indicating either party was so destitute that they couldn't pay their fees, or alternatively, the attorneys couldn't get their fees upon the conclusion of the case. The appellate court also notes, from a historical standpoint, they are typically hesitant to uphold liquidation of a home while a dissolution case is pending. So my takeaway isn't that a judge can't order a piece of property be sold to satisfy interim attorney fees per se, only that the circumstances for such an order, well, they probably have to be extraordinary. And absent that, the safe harbor for interim fees is going to be limited to incomes and bank accounts. Anyways, that's all I have. Thanks for watching.